So let's continue our discussion on the standard of care or healthcare liability, causes of action, and the elements that we need to prove. So we've talked about duty, we've talked about standard of care. There's another application, if you will, that we want to consider, and that's the application of the res ipsa loquitur doctrine. And that doctrine means the thing speaks for itself. That doctrine is applied with scrutiny in healthcare liability cases. And the main reason that we generally in healthcare liability cases that the law says that you have to have expert testimony and proof of a national standard and what's in the literature, what's in peer-reviewed journals, have experts talk about it, is because healthcare is very complex and healthcare providers have to go through rigorous education and training to practice their profession, whether it's medicine, whether it's nursing. And so it's not something within the mindset or the knowledge of a lay juror. So they rely on experts to essentially teach them what is the medicine, what should have been done in this particular case, what was the standard of care, and how was it met or not met. But in a res ipsa case, it shifts the burden of proof. And so that the plaintiff no longer has the burden of proving that the healthcare provider was negligent or breached the standard of care. In a res ipsa case, that burden of proof may be shifted. Now, often, again, like we said, it's applied with scrutiny in healthcare liability cases. So it may just be a shifting to an inference that the standard of care was not met and not a presumption that the standard of care wasn't met and actually caused the harm. So really an inference, not a presumption. The plaintiff may still be required to present expert testimony as to what the standard of care was, and also expert testimony would likely still be needed on causation, but again, it may shift the proof in some ways. How is this generally applied? About the only cases in healthcare where a judge will let res ipsa apply is in a retained foreign body case. Let's look at an example of how that might be and why it might be within the juror's lay knowledge to know if something was done incorrectly. And this is just a visual that we'll take a look at. All right, there's our visual on a res ipsa case. You're going to have, the jury may see, hey, these are all the, pieces of equipment that the surgeon was going to use in a particular case. So whenever you're going to do surgery, you do sponge counts, you do equipment counts. They'll count all of these, different, whether it's hemostats, whether it's scissors, and there'll be counts of every single thing that's used in the surgery. What was on the tray, what was actually used. You count the dirty equipment plus any remaining clean equipment, and it all should work out the same. And if your counts are right, there certainly shouldn't be something in somebody's, left inside of them whenever the surgery is complete. So a jury can understand that. A jury understands that if you end up with an x-ray that looks like this one here with a hemostat, that was inside the body, that something didn't go right. And so the courts will say in a foreign body case such as this, that res ipsa may apply and there can be an inference of negligence, that something went wrong and that the plaintiff may or may not be required to provide expert testimony on what the standard of care was and whether it was breached or not. The next element that we'll talk about in a healthcare liability or negligence case is proximate cause. And the plaintiff must prove that the negligence of the healthcare provider proximately caused the plaintiff's injury. There's two types of proximate cause. You've got cause in fact, and that's that the negligence was a substantial factor, and without negligence, the harm would not have occurred. And also that it was reasonably foreseeable. So they'll look to say, well, should the healthcare provider have known that if they took this course of action and did this or did not do this, that it was reasonably foreseeable what may happen. So if you've got a patient who, has their heart rate normally should be, around 80, and their heart rate drops down to 20. And the healthcare provider doesn't do anything about it, doesn't call for help, doesn't look to see what the problem is, just silences the monitor. Is it reasonably foreseeable that that heart rate may continue to drop and that the patient may actually code and need resuscitating. Yes, that generally would be reasonably foreseeable depending on the fact situation, but that is a piece of or a part of proximate cause. It's important to know that there can be more than one proximate cause. So you may have a hospital that transfers a patient to another hospital, and there may be an allegation that hospital A that transferred was negligent in their care of the patient. They sent them to hospital B, that the transport team was negligent, and then when they got to hospital B, that they were negligent. And they would need to prove all of that. Plaintiffs would have to prove all of that, but they can say hospital A was a proximate cause of the harm, the transport team was a proximate cause of the harm, and hospital B was a proximate cause of the harm. So there can be more than one proximate cause, and that is one way to bring in more than one or several defendants. Expert testimony is going to then be required that the healthcare provider's negligence was a proximate cause of the patient's harm. And again, that will be expert testimony almost across the board that is provided by a physician. You can have a nurse, or you generally will have a nurse expert testify as to what the standard of care is for another nurse in a case. But when you come to, did that nurse's potential breach of the standard of care cause harm to the patient, the causation piece or the harm is generally going to require physician testimony. So the final element is harm. There are several different types of harm. There's actual and compensatory harm. And two types of actual or compensatory harm. One is economic damages, and those are damages that are fairly tangible, and you can, prove them with some degree of, we know exactly what this is, such as medical bills. And, the medical bills in a case will be discoverable. Both sides will have the medical bills. They can look at the documents and determine exactly what the medical bills were. Lost wages is another tangible item. What did this person make, every week, or what was their salary monthly? They were off work for, 5 months, so they lost 5 months of wages. They were scheduled for a promotion and that didn't happen. The promotion would have increased their wages by this amount. So if it's tangible, you can look at documentation, it can be proved, then those are types of economic damages. Then we have non-economic damages, which are sometimes referred to as soft damages. They're really more intangible type of things, and it's hard to put a price on them and hard to show exactly how much is this worth. So non-economic damages are things like pain and suffering. How do you put a price on pain? How do you put a price on suffering? How do you put a price on mental anguish? Those are still damages that come in, but they are more difficult to prove. And then there's also exemplary or punitive damages. And those generally are going to require proof of fraud, malice, or gross negligence. So a judge will decide whether exemplary damages can be alleged, and if there's enough evidence to show that there was something in addition to the negligence alleged. Was it above and beyond that? Was it gross negligence, or was it done with malice, or was it in reckless disregard of the patient's well-being and safety? So precipitating causes of healthcare liability claims, there's several, and we see these over and over in allegations. Poor record keeping or poor documentation is definitely something that's a precipitating cause. Now, again, documentation is generally it is one of the major pieces of evidence in any healthcare liability claim. There are record-keeping requirements, documentation requirements that are primarily there for continuity of care and to make sure that patients get good care. But in retrospect, you can go in and look at the electronic medical record or any medical record and determine, what was the care here? And let's look at that. And was it accurately or adequately documented? So if you've got really good documentation of bad care, well, that will not be good for the healthcare provider. If you've got very good documentation of very good care, then that's going to be good evidence that the standard of care was met and that the healthcare providers followed the standard of care and provided this patient with appropriate and adequate care. Criticism of colleagues often precipitates healthcare liability claims. It's somewhat human nature. plaintiffs will say, well, I really never thought about filing a lawsuit against my physician before until I went to this other physician who said, oh my goodness, you know, why were you being treated this way? I would never treat a patient this way. And the second physician may not have intended for it to prompt the patient to file a lawsuit against the first physician, but that's often the impact of it. So it's very dangerous for healthcare providers to comment on another provider's care or treatment. They may not have all the facts, and finger pointing is one of the first things that will happen. And I always tell people, if you point fingers at somebody, it may point right back to you, because you know, the person you're pointing fingers at may say, oh, no, it wasn't me, it was them. And then the plaintiff will sue everybody, because they're like, well, we don't know exactly which one of you did something wrong, but apparently, you know, the first physician thinks that the second physician did something wrong, the second physician thinks it's the first physician, so we'll just sue both of you. So finger pointing is not something that healthcare providers generally should do. What they can tell the patient is, I don't know, I hear you have concerns. You know, you'll need to talk to someone to figure out, and they'll need to look at all the facts of the case and all the facts that are applicable to, you know, what was going on with your care. It's a much better way of managing that. Self-criticism is also something that prompts many healthcare liability claims. I think being transparent and saying, I'm sorry, whenever there was a medical error is extremely appropriate, and something that healthcare providers need to do to build trust and confidence in their patients, and it's the ethical right thing to do. But there's a difference between being, I'm sorry for what this outcome was, or being transparent about, you know, we think there may have been an error. It's always better to say, you know, we think that there was an overdose of a medication, but we are reviewing that to determine what happened, rather than just going in and falling on the sword and saying, I did this, I was wrong, this is all my fault, I'm so sorry, because you may not be the one at fault, and it may have been something completely different. So you really have to look at all the facts surrounding an issue or even an error before, you know, like letting the person know, or completely taking responsibility for what happened, because it may not be, you know, after it's thoroughly reviewed, what you thought at first happened. So providers need to be careful about self-criticism, and really be open and honest and transparent, but tell the patient, let's see, we're going to review this, we're going to try to figure out what happened and why it happened. Poor bedside manner. You know, healthcare providers who are rude or seem uncaring, they may not be, they may be in a hurry. They may be a lot of things, but they are doing themselves a disservice as a healthcare provider if they have poor bedside manner, or if they indicate to the patient that I may not have enough time for you. Patients and families, they generally do not sue healthcare providers that they know and that they like. So, you know, I have seen some not so good healthcare practitioners who never get sued because their patients know them, they like them. They may have lots of errors, they may have lots of, you know, judgment problems. They may not be providing the best care out there, but their patients love them, so they don't ever get sued. And then there could be a stellar, you know, healthcare practitioner or physician who is amazing, does great work, has the best credentials, is got just incredible skills, and, you know, is really known as being at the top of their profession, but they seem rude and uncaring, and patients don't like them, so they will get sued fairly frequently. So there is somewhat of a correlation between suing people that you don't like versus not suing people that you do like, and oftentimes that correlation may be stronger than the care that's actually provided. Poor judgment. I think that kind of goes along with the last one, which is incompetence. But, you know, making poor judgments or just being incompetent in your field as a professional is clearly, you know, a way for there to be errors or a standard of care not met. So, you know, any healthcare professional and provider, that's why they're required to have certain licensure requirements, keep up continuing education, not take on things that are outside of their scope, not do new procedures that they haven't been trained in, those types of things. And then finally, communication breakdown. And this is a system issue often. I mean, there are so many communication requirements in healthcare. Healthcare providers and the entire team all needs to be communicating with each other. They need to be communicating with the patient. And when those communications break down, failure to notify someone of something, failure to make sure that the whole team knows what the plan of care is, failure to keep the patient, you know, in the loop and let the patient have a say about their own care. All of those, you know, areas are ripe for communication breakdowns, and those can precipitate healthcare liability claims. Other causes of action against healthcare providers, it's not all negligence. Now, the vast majority of claims against healthcare providers, whether they're institutions or whether they're individuals, are going to be negligence-based malpractice type actions. But then healthcare providers are also subject to being sued for intentional torts. And so just quickly, we're going to go over a few of those that are the most common, not the only ones by any means, but that are the most common that we see in healthcare. And one is assault and battery. And that is why we have consent forms. Basically, when you walk in the door of a healthcare institution, whether it's a hospital or some other type of entity, or walk into a clinic for care, one of the first things they're going to do is have you sign a consent form that you're consenting to care in that facility or by that provider. And without that, just even general consent, then there can be an allegation of assault and battery. Then there's false imprisonment, that we held this patient against their will. I mean, if you're an adult competent patient, you're generally going to be allowed to leave a facility against medical advice. And holding that patient, there would have to be a determination that the patient was a danger to themselves or others, and that they weren't competent to make good medical decisions or healthcare decisions before you would really even have an argument that you could hold that patient. There are also strict requirements on restraints. You can't tie people down. You can't hold them down without following some very strict requirements of regulatory and accreditation bodies on how you have to restrain people. And generally, it's the least restraint that's available that is going to be the requirement for healthcare providers. Otherwise, you will have accusations of false imprisonment. Patient abandonment, we talked about that some with in terms of terminating care. This is particularly one that can be alleged against a physician who can, you know, choose to care, but once they choose to provide care, then they have a fiduciary duty to provide care for that patient until it's properly terminated. So patient abandonment is an allegation that a patient can make if a physician just says, I'm not going to provide you care anymore, you're not paying me. Well, if the patient then is not able to get an appointment, is not able to be seen, and they have a problem that develops, then they may not only have a, you know, negligence, but it's based on you abandoned me as a patient in a time that I needed care. And then sexual assault. Sexual assault is something that can be alleged against healthcare providers, and we've probably all seen, you know, news reports and, you know, articles in the media about, you know, this healthcare provider or that healthcare provider abusing patients when they were, you know, incompetent or possibly comatose, or, you know, in some other setting or situation that was inappropriate, and there's an allegation of sexual assault. So those are intentional type torts. Now, if there's an entity and it's properly screened its employees, or it's, you know, the physicians that might be on the medical staff, they've done criminal background screenings and so forth, and clearly there's policies on how patient care would be done, then most of these intentional torts may not be, again, as long as they had good policies in place and that they monitored their employees and the different providers working in the hospital, then the intention of a bad actor may not be able to hold up against the entity, but it would be against the provider or the person that actually performed the intentional tort. Discovery in lawsuits is another topic that we'll briefly talk about. And people have a different opinion or understanding of what's confidential versus what may be discoverable. So discovery in lawsuits is generally fairly open practice. I mean, we have both written discovery, which are interrogatories, requests for production, those types of, it'll be questions back and forth between the parties. And typically you'll see those as request for disclosure, request for production, and interrogatory. So each side will have to answer in writing the questions of the other side. If there's discovery that needs to come from a third party, but somebody who's not involved in the lawsuit, then generally there will need to be a subpoena for that information. And then there's depositions. And again, you can depose people who are actually a party to the lawsuit, and sometimes third parties that may be fact witnesses, but not a party in the lawsuit. And in those types of discovery, again, it's fairly open, and the courts will give a good deal of leeway in asking questions. And oftentimes I'll have physicians or healthcare providers say, why are they allowed to ask me, what my education was? Did I ever, fail a test in, medical school? Did I, pass my boards on the first time? How is that relevant to this case? But the courts will allow a good bit of leeway in allowing open discovery in cases so that the parties can find out information about each other. I mean, you can ask the plaintiffs about their income, about their, IRS filings, about, jobs, about family, how many times they've been married, where they live, all types of things that can come in discovery. So there are a lot of things that can be discoverable, and then there's some things that are protected from discovery. So in any entity, they're probably going to have various types of information that might be proprietary and it might be confidential. But being confidential in and of itself doesn't mean it's protected from discovery. So it's got to be privileged information to be protected from discovery, because otherwise, even if it's confidential, if it's relevant, then the judge is likely going to let the information come in as evidence unless it's properly protected as a privilege. And a lot of jurisdictions now have peer review protections. Texas has some very strong peer review laws. The medical peer review privilege is set out in the Texas Medical Practice Act, and it's a strong privilege and a protection for information. The rationale behind peer review privileges is that there was an allegation for many years, and again, this is several years ago, but that there was a code of silence, and that physicians or healthcare providers wouldn't testify against each other, or wouldn't say, either I committed an error or some, wrongdoing or breached the standard of care, or that my colleague did. And that even if care was reviewed, that there might be this sort of protection of silence, and wanting to improve healthcare. And we're going to talk about that when we get to our quality sections. But the law said, yes, we need healthcare providers to be monitoring each other, to be monitoring themselves. So we want that to be done as a form of peer review. Committees are formed, they look at care, but we're going to protect that care as long as you do it right and you authorize this particular or that committee to do peer review, and they maintain that information as confidential and privileged, and they cloak it in that privilege. Then we're going to recognize that privilege. The peer review protections are probably the strongest privileges to not let information in a healthcare liability suit. And again, the rationale is so that the healthcare bodies or entities will review care and be open, that individual providers will come forward and say, yes, I think this was a problem in this case. Yes, the pharmacy made an error in this case, or this nurse made an error in this case, or this physician made an error in this case. And here's what we need to do to prevent this from ever happening again. So it's sort of an overall, let's make care better, and we will be able to protect some of our information in our review as protected peer review to encourage people to come forward and be transparent and open, and encourage that type of thorough review to make care better. Now, again, some people think, oh, then you just protect and privilege the entire situation. No, because the underlying, let's say there's a medication error, that's going to be documented in the medical record. Here's the medication ordered, here's the dose, here's the route and so forth, that should be documented with every single medication. And then you've got what the documentation was, and the documentation is here's what was given, and that's different than what was ordered. So the underlying issues could come to light. And again, there's a huge move towards transparency in talking to people about errors that occur and so forth, but there will be certain part of that review process that's maintained as being privileged. That's our final. We will end today with a cartoon and a healthcare liability. And this one is this doctor holding up an x-ray telling the patient, I don't like the look of these. I better send them up to legal. Just so that you get the feel of this is a highly regulated area. There's a lot of information. We talked about tort reform, and in our next couple of classes, we're going to talk about ways that our healthcare delivery system monitors and tries to provide good care and care that's according to a certain standard of practice and that's quality care. And there's a lot of movement towards patient safety. As part of that, the legal system is a part of it, because legal system and compliance also imposes a lot of requirements. And so it's good for a hospital or healthcare facility or healthcare provider to know, in fact, it's essential for them to know what are the legal guidelines and requirements for my practice. I need to know what my licensure, laws are and what regulations are that govern my practice, and I need to be able to comply with those. So the legal realm of healthcare is a very important part of it, and it is good for healthcare providers and entities to work closely with attorneys, whether they're inside attorneys or outside attorneys, to know what those requirements are. Thank you for your patience, and we will talk more hopefully this week on our discussion boards about some of these issues.